Right now, across this country, in nearly every town, in every county, in every apartment building and single-story ranch where an immigrant senior is cleaning lunch dishes or sitting beside a kitchen radio, there is a quiet, hidden tax on American seniors who do not understand what they are legally allowed to keep today. If you are a green card holder who is 62 or older, if you are a naturalization applicant who has lived in this country for 20 years and finally gathered the courage to file the form that gives you citizenship, and if you are depending on Social Security income, retirement savings, or remittances from a son or daughter working inside the United States, then this video is for you today. The bills are real. They arrive by mail every month. They look official. The county assessor sends them. The phone company sends them. Your bank sends them. The state revenue department sends them. Your pharmacy sends them. But what most seniors do not know, and what most adult children do not understand, is that 5 of the bills you are paying right now are legally exempt for you under federal and state law. And the money you are sending out the door is the exact money your immigration case file at United States Citizenship and Immigration Services will judge you on inside the next 12 months of 2026. Continue paying these 5 bills, and 4 things will happen in sequence, and none of them are good. First, your monthly retirement budget collapses by hundreds of dollars you did not need to spend, and over a 12-month calendar year, that total reaches thousands you could not afford to lose. Second, your ongoing case at the United States Citizenship and Immigration Services becomes harder to defend because the financial documents you need to present no longer match the lifestyle and the housing stability that the reviewing officer expects to see on the record today. Third, a benefit you spent 3 or 4 years fighting for, like the senior homestead property tax exemption, like the income tax freeze on Social Security benefits, like the Medicaid spend-down protection that would have paid your Medicare Part B premium, gets denied silently because you never filed the simple one-page form that would have flipped the denied line into an approved line. Fourth, and this is the part nobody wants to talk about at the dinner table, your immigration status itself quietly comes under review because the same financial pattern that drained your monthly cash flow showed up in a database the Department of Homeland Security already reads, and the story it tells on your immigration record is not the story you wanted written there today. Before you scroll past this and assume this is fear-mongering, hear the source plainly. This is not a rumor on WhatsApp. This is not a whisper in a coffee shop. This is not a viral post on TikTok from a creator who never opened the Federal Register. This is the law, written in plain English, sitting in the same statute book the United States government uses when it files its own enforcement actions across this country right now, today, this week, in 2026. If you close this video without hearing about the one bill that almost every senior immigrant pays and almost none of them are exempt from, you will walk away missing the precise piece of information that decides whether you keep your status or quietly lose it inside the next 12 months. For decades, this country has had a law on the books stating that certain seniors, certain low-income retirees, certain long-term lawful permanent residents, and certain senior families sponsoring close relatives do not have to pay specific bills that almost everyone else pays every single month. The law itself is not new and was not created yesterday. The original statute most often cited in federal enforcement actions is Section 5313 of Title 31 of the United States Code, which governs currency transaction reports, paired with Section 5324 of Title 31 of the United States Code, which governs the federal crime known as structuring, paired with Section 101F of the Immigration and Nationality Act, often shortened to INA Section 101F, which is the part of federal immigration law that defines what the United States Citizenship and Immigration Services calls good moral character during a naturalization interview. These 3 statutes were written long before 2026. They were updated and clarified through a published rule signed in 2024. They were operationalized through a Memorandum of Understanding signed in 2025 between the Financial Crimes Enforcement Network inside the United States Treasury Department, the Department of Homeland Security, United States Citizenship and Immigration Services, and the Social Security Administration. That memorandum governs how reported financial data moves between the 4 agencies, and the memorandum is in active force right now, today, inside 2026. The reason this video exists today is not because a new law was passed last week. The reason is because enforcement shifted this calendar year, and a higher number of officers are reading these reports than in any prior year on record. More automated alerts are firing inside the immigration case management database. More seniors are finding out about the exemptions only after the fact, when the window to claim them has closed for tax year 2026. Most seniors, when they think about what actually triggers an enforcement review in 2026, assume the triggering number is $10,000. They have heard on the news and they have heard at the kitchen table that you have to deposit more than $10,000 in cash or send more than $10,000 out of the country in a single transfer before anybody in the federal government pays real attention to your file. That $10,000 number is not the real trigger today, and the gap between what people think the trigger is and what the trigger actually is, that gap is where the danger lives in 2026. The actual triggering threshold for the kind of report that now flows into immigration case files is $0, and that is not a metaphor or a scare tactic. The Suspicious Activity Report, the form that every federally insured bank and every money services business is required to file with the Financial Crimes Enforcement Network whenever a transaction looks unusual, has no minimum dollar floor written into the regulation. A $300 cash withdrawal from an account you have held steady for 15 years, at the same branch you have visited every other Friday for a decade, can trigger a suspicious activity report if the bank's automated fraud detection algorithm decides the pattern is unusual compared with the average customer inside your zip code. A $2,000 wire transfer as a gift to a grandchild studying abroad can trigger a suspicious activity report if the bank employee behind the counter decides the transfer looks unusual. A series of 3 transfers of $9,900 each in a single 7-day window, even if every individual transfer is below the $10,000 floor, can trigger multiple suspicious activity reports because 3 transfers of $9,900 in the same week is the textbook pattern of structuring, which is the federal crime defined in Section 5324 of Title 31 of the United States Code, and structuring charges have been filed against lawful permanent residents in removal proceedings in 2024, again in 2025, and again increasingly throughout 2026. The real number that triggers the new enforcement is much smaller, and almost nobody knows it. To understand why these 5 bills matter so much in 2026, you have to picture clearly how the financial world talks to the immigration world, because the two worlds are now wired into one another through a data pipeline built by the memorandum signed in 2025, and that pipeline runs every single day now without anyone signing a consent form. The flow of information begins at the Financial Crimes Enforcement Network, which I will shorten today to FinCEN, the office inside the United States Treasury Department that receives and processes almost every currency transaction report and almost every suspicious activity report filed by every insured bank, every credit union, every money services business, and every wire transfer originator operating inside the territorial United States. By federal statute under Section 5313 of Title 31 of the United States Code, every financial institution must file a currency transaction report whenever any cash deposit, withdrawal, exchange, or transfer reaches or exceeds $10,000 in a single business day at or through the institution. So a single visit to a branch teller, a single withdrawal from an ATM that crosses $10,000 in one day, a single cashier's check purchase at or above $10,000, all generate an automatic federal report filed the same business day today. Then FinCEN shares those reports through a data system called the Bank Secrecy Act database, often called the BSA database inside federal enforcement circles. And that data system is now linked, through the memorandum signed in 2025, directly into the case files at United States Citizenship and Immigration Services, shortened today to USCIS, and into the enforcement dashboard sitting inside the Department of Homeland Security, shortened today to DHS, where officers from Immigration and Customs Enforcement and officers from Customs and Border Protection read the same financial patterns in real time before they sit down across from your interview chair. Then the Social Security Administration, often shortened to SSA, feeds wage and benefit data into the same pipeline through its own data sharing agreement under Section 613 of Title 42 of the United States Code, the section that governs the administration of federal retirement benefits. So the wage history tied to your Social Security number, the bank account your direct deposit lands in every month, the remittances flowing out of that same bank account every month, all show up as a single row inside a database an immigration officer can pull up on the morning of your interview date in 2026. The pipeline is automatic. It is not optional for the agencies. It is not subject to your consent. The officer at your interview seat is reading your money just as clearly as you read the bills that arrive in your mailbox today. The first character I want you to meet is Maria, a lawful permanent resident originally from El Salvador who has lived inside the United States for 22 years and works as a certified nursing assistant at a memory care facility in Houston, Texas, where she earned $36,400 in 2025. Maria filed Form N-400, the application for naturalization, in February of 2025, and her interview was scheduled for November of 2025. But the case has been frozen because, according to the written request for evidence she received at her home in October of 2025, the reviewing officer wants more documentation about the recurring pattern of her bank deposits across calendar year 2024 and calendar year 2025. The pattern in question is straightforward, and it is the pattern most retirees and pre-retirees fall into without realizing it. For 3 years, Maria has deposited her weekly paycheck in one bank, has withdrawn between $300 and $700 in cash every Friday afternoon for groceries and for a small remittance to her mother living in San Salvador, and then has made a smaller, separate wire transfer in the same week to her sister living in California, who is also a lawful permanent resident, to help with her sister's mortgage payment. None of those transactions crossed $10,000 in any single week during 2025. None of them triggered an automatic currency transaction report under Section 5313 of Title 31 of the United States Code. But in August of 2025, her bank filed 3 separate suspicious activity reports on her account because the bank's automated fraud detection algorithm flagged the recurring weekly cash withdrawals as outside her normal pattern compared with the average customer inside her Houston zip code. Those 3 suspicious activity reports were forwarded by FinCEN to the Department of Homeland Security, where they were associated with Maria's pending Form N-400 file, and the immigration officer generated the request for evidence that today sits on Maria's kitchen table in Houston waiting for a response. Maria's case is not closed today. Maria's status is not revoked today. But Maria's processing timeline just moved from a 5-month wait to a 15-month wait, and the extra 10 months of wait time are the precise bill she did not know she was paying today. The second character I want you to meet is Hong, a lawful permanent resident originally from Vietnam who has lived inside the United States for 31 years, retired from his assembly line job at an automotive parts manufacturer in Warren, Michigan in 2024 and currently receives Social Security retirement benefits of $22,400 a year, plus a small pension of $8,400 a year from his former employer, for a combined annual retirement income of $30,800. Hong and his wife Lan own their home in Dearborn, Michigan, free and clear of any mortgage balance, and they have 2 adult children, one a U.S. citizen by birth and one a lawful permanent resident who has filed Form Y-751, the petition to remove conditions on residence that conditional residents must file in the 90-day window before the 2nd anniversary of getting the conditional green card. Hong's son filed Form 1751 in 2024, and Hong signed an affidavit of support under Section 213A of the Immigration and Nationality Act, often shortened on the form itself to I-864, promising to support his son at 125% of the federal poverty guidelines for the applicable household size if the son could not support himself. In the spring of 2025, Hong and his wife Lan lost the appeal of their Medicare Part B premium surcharge, the income-related monthly adjustment amount surcharge that adds between $200 and $300 a month to the standard Medicare premium for retirees whose modified adjusted gross income from 2 years earlier exceeded a set federal threshold. Hong did not know he could file Form SSA 44 with the Social Security Administration to appeal the surcharge after his earned income dropped in retirement, so he and his wife kept paying the surcharge out of the regular savings account they had built up over 31 years of working for the same employer. By July of 2025, the savings account balance had fallen below $15,000, and the Hong family started using a home equity line of credit to make ends meet each month, which generated a series of irregular deposits and withdrawals on a quiet account that had until then been completely untouched. By September of 2025, the home equity line activity triggered two separate suspicious activity reports. Those reports flowed daily to FinCEN. FinCEN shared them onward with the Department of Homeland Security, and the Department of Homeland Security flagged the I-751 case file as needing secondary review. Today, Hong's son is waiting for that secondary review to clear, and the standard wait time is 6 to 9 additional months long in 2026. The bill Hong was paying was the same bill he could have stopped paying 2 years ago when his income dropped, and the cost of not stopping is now showing up on his son's immigration record today. In a regular federal tax audit, when the Internal Revenue Service has questions about the bank deposits or about the cash withdrawals on your personal account, the burden of proof sits on the government to show you that something is wrong with the return you filed. You sit across from a revenue officer. You bring your records. You explain the bank statement line by line. The Internal Revenue Service officer has to convince the tax court that the return you filed was wrong, and the standard of proof the officer has to meet is high, and the document filing responsibility belongs to the United States government. But immigration court does not work that way at all. In a removal proceeding under Section 240 of the Immigration and Nationality Act, in a Form 751 review under Section 216 of the same Act, and in a naturalization review under Section 316 of the same Act, the burden of proof shifts to the applicant to prove that the financial pattern the government sees on the record is consistent with a lawful, stable, and financially responsible life inside the United States. The immigration law specifically adds a requirement in Section 316 that every naturalization applicant must demonstrate good moral character for the full 5-year statutory period, or for the full 3-year statutory period in the case of a spouse of a U.S. citizen, before the application can be approved. Section 101F of the same statute defines good moral character in part by your financial behavior over the statutory period, including the truthfulness of statements made to financial institutions and the reliability of any financial documents you submitted to support your case. So the same fact pattern, the same $300 withdrawal, the same $9,900 wire transfer, the same missed property tax exemption on the same Friday of the same month of the same year in 2026 can be a quiet footnote in a tax file at the Internal Revenue Service and a loud alarm inside the immigration case file at United States Citizenship and Immigration Services. This is why every senior immigrant needs to understand that the dollar amounts they treat as ordinary today, the United States immigration system treats as evidence today. While all of this is happening inside federal databases, a parallel network of predatory consultants and unlicensed tax preparers is busy turning senior anxiety into cash and turning the cash into permanent damage to the senior's case file. These consultants show up at kiosks in strip malls outside Federal Plaza, at folding tables placed outside the Social Security office waiting room, at booth rentals at the Saturday Community Market, and they hand out glossy flyers with phrases designed to sound official. They say things like, "Are you worried about your citizenship interview? We can fix it." Or, "Are you paying too much in tax this year? We know the secret IRS program." Or, "You have to renew your green card before they take it away from you. We can help today." Or, "We have a special senior program, only for retirees, only today, only here." They charge $3,000 upfront, $5,000 upfront, $8,000 upfront for what looks like a complete fix for the senior's problem. They file the wrong forms. They miss the legal deadlines. They coach the senior to lie about the bank account at the upcoming immigration interview. They put the senior in a worse financial and legal position than the senior was in before the consultant walked through the door, and they leave the senior with a fraudulent immigration filing that becomes a brand new problem inside the immigration database the moment the case is reviewed. The three most common scams circulating inside the senior immigrant community in 2026 are the notario scam, where a person who is not licensed as an immigration attorney represents himself or herself as a licensed attorney and files immigration forms they have no legal authority to file. The Form SSA 44 scam, where the consultant charges between $500 and $1,500 to file an income recertification appeal that any senior could have filed completely free of charge in 15 minutes by mail with the Social Security Administration, and the affidavit of support coaching scam, where the consultant pressures a family sponsor to overstate household income inside the Section 213A paperwork, and then files supporting bank letters and IRS transcripts that do not match the real numbers on the senior's actual bank statement. If somebody asks you to pay more than $150 for help with one simple Form N-400 filing, slow down right now. Here are 7 specific actions you should take right now inside 2026 before another one of these 5 bills arrives in your mailbox. The first action is to open your mailbox this week and pull out every property tax bill you have paid in the last 24 months. Find the envelope marked School District Levy or marked School Tax, and look closely for the line that says Senior Homestead Exemption or marks Additional Exemption for persons 65 and older. If your county or your state offers an additional homestead property tax exemption for homeowners 65 and older who have owned the same primary residence for at least 5 years, you are likely eligible for an additional exemption that, in states like Texas, Florida, and Georgia, can reach $10,000 of taxable value removed from your annual bill. File the Senior Homestead Exemption claim this month before the next installment bill arrives, and bring the green card or the naturalization certificate and 2 proof-of-age documents to the county assessor office in person. The second action is to open your state income tax return from tax year 2024 and look closely at the line where Social Security income is reported or where pension income is reported. If you live in one of the 34 states that exempt Social Security retirement income from state income tax, including Florida, Texas, Pennsylvania, Illinois, Ohio, Michigan, Georgia, and most of the others, then check whether your pension payer is still withholding state income tax from your monthly pension check out of caution. File Form W-4V with the Social Security Administration to stop the withholding on the Social Security check. File a corrected state withholding form with the pension payer, and you may recover between $500 and $3,000 a year in refunds for tax year 2026. The third action is, if you are paying an income-related monthly adjustment amount surcharge on your Medicare Part B premium because your income 2 years ago was higher than the federal threshold, file Form SSA 44 with the Social Security Administration this week because the surcharge is appealable in writing whenever your income has dropped due to retirement, divorce, death of a spouse, return to work, employer settlement, or other documented life-changing event. The fourth action is, if your bank is charging you a monthly maintenance fee, a per-check fee, or a printed statement fee on a personal checking account, walk into your local branch with a government-issued photo identification and ask for the senior waiver by name. Federal banking guidance and many state laws require most insured depository institutions to offer fee waivers to account holders who are 65 and older. If your bank refuses to waive the fee in writing, switch banks on the spot. The fifth action is, when a bill you have never missed before shows a late fee for the very first time in your life, call the issuing agency the same morning and ask for a first-time abatement. Federal student loans, property taxes, water and sewer bills, and many other government and quasi-government bills waive the late fee for first-time offenders under widely known internal policies. The sixth action is to schedule a 30-minute appointment at your local area agency on aging office inside the next 45 days, because the staff at every area agency on aging office routinely reviews senior exemptions case by case, and they do not charge a single dollar for the meeting. And the seventh and final action is to refuse to pay any consultant any sum in advance for assistance filing Form N-400, Form Y-864, Form SSA 44, Form W-4, or any other federal immigration or tax form, unless the person helping you is a board-certified immigration attorney in good standing inside the state bar of the state where they practice, and unless they will give you their attorney bar registration number in writing before you sign any document or before you hand over any payment. The most important thing to hear today is that preparation is a form of power and not panic. Because the seniors who quietly lose their status in 2026 are not the seniors who had the smallest bank account and not the seniors who failed the language test, but the seniors who never opened a single exemption form. The seniors who keep their status, who keep their benefits, who keep their husband's pension, who keep their daughter's legal right to permanently stay in this country, are the seniors who pull their paperwork out of the shoebox this week and look at it one page at a time. From the bottom of my heart, I want to thank you for spending a few quiet minutes with the Senior Life USA channel today, because I built this channel for the grandmother in her apartment in Queens who learned English in her 50s at the community center, and I built it for the grandfather in his garage outside Houston who never asks his adult children for help with money. And I built it for the auntie in Chicago who still sends $300 a month back home to her mother in the Dominican Republic, even though her own savings account balance is small. If this channel has helped you today, please tap the subscribe button below and turn on the bell notification right now so a fresh new video lands in your feed the same morning it goes live, because I publish new senior immigration videos every Tuesday and every Friday aimed at exactly your situation. In the comments section below this video, tell me one specific thing about your case. Tell me your immigration status in plain simple words like green card holder or naturalization applicant or H-1B visa holder or U.S. citizen sponsoring a parent, so I can pick the very next topic that fits your life. And please share this video with one specific person in your life today, the one parent, the one sibling, the one close friend from your home country who is still paying 5 bills they should not be paying right now, because the share button below this video is the difference between a quiet frozen case and a clean approved case inside 2026. End the panic today by opening the envelope today, by filing the simple form today, by asking the question today. Preparation is the new power now in 2026.